You know what? Hurts more than a last lap incident at Daytona. Watching the sport you love slowly tear itself apart under fluorescent courtroom lights. NASCAR was built on speed, rivalry, and raw emotion, not subpoenas and sworn testimony. But today, the most important battles in stock car racing are no longer happening on the track. They are unfolding inside a federal courtroom in Charlotte. At the center of it all stands an unexpected challenger, Michael Jordan, not as a brand, not as a sponsor, but as a team owner willing to confront NASCAR's entire power structure. For decades, teams complained quietly, fans grumbled online, insiders whispered behind garage doors, but no one pushed back publicly. Until now, when two race teams refused to sign NASCAR's new charter agreement, it sent shockwaves through the paddock. Every other team signed, these two did not. Instead, they chose a far riskier path. They chose court, and what followed exposed internal conversations, private frustrations, and leadership attitudes that many fans suspected for years but could never prove. This lawsuit is not about one contract. It is about who truly controls NASCAR and whether the sport's future can survive the way it has been run for nearly 8 decades. As the trial unfolded, one detail stunned even longtime observers. Leaked text messages from NASCAR President Steve Phelps surfaced, revealing deeply personal and inflammatory language about Richard Childress, one of the most respected figures in the sport. Childress is not just another owner. He is a Hall of Famer, a former driver, and the man who owned Dale Earnhardt Sr.'s iconic car. According to court exhibits, Phelps referred to Childress using language that many interpreted as dismissive and insulting, language that went far beyond professional disagreement. When those messages became public, the reaction was immediate. Fans felt vindicated, owners felt exposed, and NASCAR's leadership suddenly faced questions not just about contracts, but about respect. Other messages revealed executives speaking harshly about fans and rival racing series. For years, many supporters believed NASCAR leadership was distancing itself from its traditional base while chasing a different audience. These texts did little to quiet those concerns. The issue was no longer perception, it was documentation, and it raised a critical question. If this is how leadership speaks privately, how does that influence the decisions being made publicly? To understand why teams finally pushed back, you have to understand the charter system. Introduced in 2016, charters were meant to provide stability. Before charters, teams could arrive at a race, fail to qualify, and go home with nothing. Charters guaranteed entry and a larger share of revenue, but they also created dependency. Teams without charters earn roughly 1/3 of what chartered teams make. Over time, charters became extraordinarily valuable assets. Early sales hovered around $13 million. Within just a few years, prices doubled, then tripled. The most recent sale reportedly reached $45 million. That kind of valuation came with strings attached. Charters are not permanent. NASCAR can revoke them, and that uncertainty is what teams say keeps them financially trapped. Owners argue they are investing tens of millions into an asset they never fully control. And when negotiations began for a new charter deal, teams believed this was their chance to finally fix that imbalance. Negotiations stretched on for nearly 2 years. Teams submitted thousands of requests. Most were denied. NASCAR did agree to increase the team's share of media revenue from 37% to 49%, a meaningful improvement on paper, but key issues remained untouched. Charters would still not be permanent. Teams would still have no formal voice in governance. Then came September 6, 2024. At 5 o'clock in the evening, NASCAR sent the final contract. Over 100 pages long, teams were given 1 hour to sign. No extensions, no revisions. Sign or risk losing your charter for the following season. 13 teams signed, not because they were satisfied, but because they felt they had no choice. Front Row Motorsports and 23 She Racing did something different. They said no, and in that moment, they crossed a line NASCAR never expected anyone to cross. The lawsuit centered on one explosive claim: that NASCAR operates as a monopoly. According to the filing, the France family controls the racetracks, the sanctioning body, the rules, and the economic structure of the sport. NASCAR countered by arguing teams had alternatives. Other racing series exist. But in November, Judge Kenneth Bell issued a ruling that shifted the entire case. He determined that premier stock car racing is its own market, and within that market, NASCAR holds monopoly power. Formula One and IndyCar were not considered realistic substitutes. This did not mean NASCAR had broken the law, but it did mean the burden shifted. The question was no longer whether NASCAR had power, it was whether that power had been abused. And once the trial began, testimony revealed just how fragile the team business model really is. Denny Hamlin was the first major witness. Speaking not just as a driver, but as a co-owner of 23 She Racing, Hamlin laid out the economics in stark terms. It costs roughly $20 million per year to run a single competitive car. That figure does not include marketing, facilities, or long-term investment. Despite the perception of wealth, Hamlin testified that teams operate on razor-thin margins. He personally earns millions as a driver, but as an owner, he has invested more than $45 million, much of it borrowed. Bob Jenkins of Front Row Motorsports followed with equally sobering testimony, stating he has lost nearly $100 million in NASCAR. The message was clear. NASCAR is profitable. Teams are barely surviving. When NASCAR executives took the stand, the courtroom atmosphere shifted. This was no longer about frustrated team owners voicing opinions. This was about NASCAR's own internal words being read aloud under oath. Scott Prime, one of NASCAR's top executives, was questioned about internal emails and data he had shared with colleagues during negotiations. In those communications, Prime acknowledged something teams had argued for years. Compared to other major racing series, NASCAR teams receive a significantly smaller share of overall revenue. Formula One teams, he noted, operate under a system where roughly half of the sport's revenue flows directly to competitors. In NASCAR, that figure was closer to 20 to 25% before the New Deal. Those numbers contradicted NASCAR's public position that teams were being treated fairly. Even more damaging were internal text messages from May 2024. After a meeting with team owners was described as productive, Steve Phelps responded with a single word: insanity. He added that the teams had achieved 0 wins and made it clear the deal would move forward, regardless of their concerns. To the jury, this painted a picture not of negotiation but of authority. NASCAR leadership appeared to understand the imbalance, yet chose to enforce it anyway, and behind those decisions, testimony suggested, stood one final voice. That voice belonged to Jim France. The CEO of NASCAR rarely appears in public, but his influence is absolute. Heather Gibbs, co-owner of Joe Gibbs Racing, delivered one of the most emotional testimonies of the trial. Her team is not a small operation fighting to survive. It is one of the most successful organizations in NASCAR history. Gibbs testified that as the September deadline approached, she personally pleaded with Jim France to reconsider the 1-hour ultimatum. According to her account, she warned him that forcing teams into a corner would damage relationships that had taken decades to build. She described the fear inside the garage, not just for owners, but for hundreds of employees whose livelihoods depended on charter security. Gibbs told the court that France's response stunned her. He allegedly said that whether NASCAR ended up with 20 charters or 30 did not matter to him. The sport would move forward either way. That moment reframed the lawsuit. It suggested that team losses were considered acceptable collateral. For jurors, it raised a critical question. If teams are replaceable, what incentive does NASCAR have to protect them? Then Michael Jordan took the stand. Unlike other witnesses, he did not speak in technical language or financial jargon. He spoke as a fan. Jordan described growing up in North Carolina, attending races at Rockingham, Darlington, and Talladega. He spoke about NASCAR as part of his childhood, not a business venture. That perspective mattered. Jordan explained that his decision not to sign the charter agreement was not impulsive. He believed the contract was fundamentally unfair. He was troubled by clauses that restricted teams from taking legal action against NASCAR. He was alarmed by the 1-hour deadline, which he felt eliminated any real choice. Jordan told the jury he was uniquely positioned to challenge the system because he was not exhausted by years of fighting behind the scenes. Other owners, he implied, were simply worn down. He made it clear this lawsuit was not about maximizing profit, His team was already sustainable. This was about creating a structure that would allow NASCAR to thrive long-term for teams, for fans, and for the sport itself. That distinction separated Jordan from every owner who came before him. As the trial continues, NASCAR faces consequences unlike anything in its history. If the teams prevail, the charter system could be ruled unlawful, forcing NASCAR to redesign its entire economic model. Revenue sharing could increase, team influence could expand, and control could slowly shift away from a single family. If NASCAR wins, the outcome may be just as severe. Front Row Motorsports and 23 She Racing could disappear. 6 cars could vanish from the grid. Michael Jordan's presence in NASCAR could end overnight. But the true stakes go far beyond any one team or owner. The France family has controlled NASCAR for 77 years, guiding it from regional dirt tracks to a national powerhouse. Yet motorsports has changed. Formula One is owned by Liberty Media. IndyCar operates under shared ownership. NASCAR remains an outlier, governed by one final authority. In 2025, the question is unavoidable. Can a modern global sport continue to operate this way, or has NASCAR reached a moment where control, not competition, has become its greatest risk?